Hello, everyone.
All
Hello,
set.
everyone. All right, awesome. Thank you, OPAT. Hello, everyone. It is 9:34. We're going to start this OPAT Commission public meeting. Uh, you know, want to thank everyone for joining today. I'm the pro tem board chair of the OPAT Commission today. I'm Peter Alvarez, the chair of the Civilian Review Board. I also like to acknowledge and introduce Judge Leslie Harris, the chair of the Internal Affairs Oversight Panel. It's great to see some members of the community joining us today. Thank you for attending. Um, we're gonna go into the agenda. If you could change to the agenda slide. Really quick. Okay, so we're gonna do an intro, review and approve past meeting minutes for 9/21, 10/26, and 12/14. We'll review the commissioner response to cases number 175 and 190, proposed regulations for OPAT, section 1, discussion of proposed 2024 board meeting dates, other business not anticipated by the chair at the time of posting, to the extent there is any other business, public comment period, and adjournment. If you need to leave this meeting before we reach comment period, please feel free to email your comments to OPAT staff at opatboards@boston.gov. That's OPAT boards@boston.gov. Our first order of business is to approve the meeting minutes from the OPAT Commission Community Meeting on September 12th and the public hearing on October 26th. So moved. Okay, I second it. All in favor, say aye.
Aye.
Aye. All right. Anyone opposed? It's just us two. So it takes it approval of the OPAT Commission meeting minutes with no corrections. Next, we will now move on to discussion of Commissioner Cox's response to the two sustained CRB cases, case number 175 and case 190. We can take a look at each of the cases. Number 175, do we have a slide for that? 175, I don't think we have a slide for it. Oh, share the file in the meeting. Okay, hold on one second. Opening it right now.
Well, he agreed with us with the CRB.
Yeah, on that one, I just wasn't sure which one, because on one he did and one he didn't.
Right.
Which one is 175? I'm just having trouble downloading it.
Well, and I can't open mine.
Yeah,
Right.
hold on, I think I got it. Just put it on my desktop and see if that works. Hold on. Okay, 175. All right, so case 175, the Civilian Review Board found sustained, and we voted unanimously 6-0 that the complaint be considered sustained on the alleged violation of the BPD rules and procedures against Officer Edward Gately based on the disciplinary matrix under mitigating penalty for first violation of this rule. The Civilian Review Board has recommended the BPD commissioner that Officer Gately receive an oral reprimand. After the review of the Facebook post, so this officer had written some unfavorable comments on the Facebook page of a different police department woman who was being honored on a police department page for a separate police department, some disparaging comments publicly on Facebook. And the commissioner found that one not sustained and did not decide to agree with our recommendation. You know, any comments here, Judge, on in your view? I would say, as part of the commission, part of the Civilian Review Board, seeing that it was a bit disappointing because it felt like it was public. It was a public comment that was being made by a member of the police department that was disparaging actually an officer from another jurisdiction. And there were a lot of gendered aspects to that disparagement, and it was unfortunate that that complaint that the commissioner did not agree with the sustained finding in the recommendation, given the facts as they lay out, and the conduct that was being done in a public forum.
And when I read I guess it was just a synopsis of I didn't get to read the whole, hear the whole hearing.
Yeah.
I'm not sure that I disagree with the commissioner, and that I don't see it necessarily as being sexist. I don't think he should comment on other police officers in another jurisdiction. But I think while it might have felt a little uncomfortable as far as sexism was concerned, I don't think it quite got there. He could have said the same thing about a male police officer, and I thought it was more politics than sexism. But I think he's learned his lesson. Okay.
Yeah, I think it being public, right? And I think, it was under a pseudonym on Facebook that the post was made. What made the Civilian Review Board, and I could speak for myself, but I think, it was unanimous, was the fact that it was a Women's History Month post for the police department that the posting was made. And he says, I'm sure she earned it. Like it was about her being in a specialized unit after, she got in 2022. Yes, she's in a specialized unit. I'm sure she earned it. There was a lot of it being a Women's History Month post and it just that kind of language. I think putting it together, obviously we can't determine intent, but it is unbecoming, and it is something that, again, the officer, the commissioner did disagree with our finding, and I think there could be folks that disagree. I think the Civilian Review Board views it as something that was the finding itself and a sustained finding on the complaint. We felt strongly that it's something that needed to be addressed, and an oral reprimand could have been the best way to address that. But I could see how people could disagree. I think the Civilian Review Board took a stand that felt pretty cut and dry, I think, based on the circumstances. But again, I think folks can disagree. I just think the CRB didn't definitely agree with the sustained finding. So yeah, so we could move to the next one. And I think when there's public comment, folks could chime in on that to the extent they'd like to. Let me get the second one. Thank you, OPAT, for adding that one to the file here. Okay. So in OPAT case number 190.
Okay, that's one.
Yes. So in this one, the rule violation that we found sustained was respectful treatment. And it was a CRB voted unanimously 6-0 that the complaint be considered sustained on the violation of BPD rules and procedures against Officer Austin Brooks. Based on the disciplinary matrix under mitigating penalty for a first-time violation, the Civilian Review Board has recommended that the BPD commissioner, that Officer Brooks, receive an oral reprimand. This was a case in which the rule violation was the officer cursing at the complainant and telling him to move the effing vehicle now, unprovoked. It was conduct that we thought was not respectful treatment of a citizen or resident, someone who was he needed him to move his vehicle, but that you could ask that without cursing at someone. In this case, thankfully, the commissioner did find they did find the sustained rule violation and did agree with the recommendation of an oral reprimand. So the commanding officer, Commissioner Cox, had an oral reprimand issued by the officer's commanding officer. So I think this is a good place. I mean, I think the commissioner agreeing with the Civilian Review Board's finding and recommendation is a good starting point. I think this is the first time that that the commissioner has agreed and agreed with the recommendation that the Civilian Review Board has put forward. I think, as I've mentioned in public meetings, this is sunshine. This is like just putting a light on things that wouldn't have come out previously. And also letting the public know that like there are things that, being treated respectfully is something that can be cause for reprimand if it's not done. And that is something that the police department needs to make sure that they're doing when they're addressing members of the public. And everything is always circumstance dependent, but in this circumstance, with these underlying facts as they were, it seemed appropriate to recommend discipline, find a sustained finding. So hopefully, as members of the public, anyone here viewing, if you have complaints that, that fit that mold, maybe make them. We can't, at the end of the day, everything is very, very fact dependent. So it's going to depend on the totality of the circumstances when being reviewed, but it is something that we want to encourage folks to think about what is what conduct they're experiencing, and encourage folks, if they have questions, look, it's just getting a second set of eyes and getting people to look at it. And I think that in itself could just make everything better, just even by a little bit. There may be a sustained finding, there may be not. The CRB may find a sustained finding, but the commissioner does not decide to agree with it. That's just the nature of how this is going to work. But I think having more to work with is always good. And I think it improves processes in our city and the police department at the end of the day. If we can take a look at more instances in conduct and make sure that, adhering to the rules that, the folks have for the officers have for themselves, but also the expectations of the community. Judge Harris, Commissioner Harris, you have anything to add there on that one?
No, I think it's good optics for the community to see that they can complain, and that we're supposed to be treated respectfully in the community. And too often we let it go, and we shouldn't, because these officers work for us. And we have to make sure we hold them accountable when they abuse the power that we give them. So I'm glad that someone stepped forward and complained. I am happy that the commissioner saw fit to agree with the CRB. And I'm hoping that this is part of a lesson and a training for police officers. So I'm satisfied.
Yeah. Likewise. I mean, look, there's always going to be more wood to chop, Commissioner Harris, but I think this is a step in the right direction. It being the first sustained finding that was, and the adoption of the recommendation. I'm heartened. Obviously, there's always so much more that can be done. And again, we encourage more folks to put stuff in front of the OPAT Commission for investigation that can then go to the Civilian Review Board. But I am heartened by the decision because I think we didn't take our charge lightly there, and we want to make sure that that the community feels listened to, because that's part of the role. We do have constraints on, the matrix itself. It has to be a violation, and the recommendations are based on the matrix as well, right? But again, if anything, it is additional sunshine, things we did not as a community have insight into in color. Now at least it comes to light. So again, want to just put that plug that you could reach out to OPAT, make a complaint online, in person, give a call. You could, with OPAT. So again, in the public comment period, folks can write public comment. You could submit them via email. And we'll take them here as well, to the extent anyone wants to say them orally on a recorded line. The next order of business, if we could move to the next slide, proposed regulations, OPAT section 1. OPAT, how do you want to like kind of have this? I think you said you put a document up. If you could increase it, I know I can't see it. I don't know about you, Judge, but I
Well, I was
can't.
stretching it out. Um,
All right, I could see that. All right, awesome. So, in section 101, I didn't have any comment here, in terms of OPAT for the folks. Did anyone send any public comment? And if so, will we read those instead? I mean, I think we can. I wanted to see, Judge and OPAT, do you think it makes more sense to just wait till the public comment period to read out comments on these regs? Because it's going to happen right after. So, right after this. So I think that might make sense, but I wasn't sure if you thought we should do them case by case.
I read the regs. I basically agree with them. I'm hoping that in the future we'll have a little more power put to it. But I am satisfied with the regulations as they're now presented.
Okay. I think in 101, I'm fine with that one. In 102, I'm fine with that one too. It kind of puts together the complaint itself and how it usually is. Incomplete complaints, 103. This is where I had a comment, and my comment was more so if we could, the OPAT will consider a complaint incomplete if it is missing 2 or more of the following information. So one thing I think, you could not, you could be an instance where you get video of someone, so you wouldn't have and you don't know who the officer's first and last name as the complainant. Only contains physical description information of BPD personnel and no other identifiable information. Again, I think that goes part and parcel with the first bullet. So if those 2 are missing and you have a video, I just think it needs to be clear that, that almost clarifying that if there's video, audio, other kinds of identifiable information, then that should be able to be investigated. It can't be incomplete because a complainant doesn't know the name, the precinct, the officer. That can't happen. So I want to be able to thread the needle and address that.
And I was thinking about the fact that we have investigators who I would hope would be able to find some of that information for the person who's trying to do the complaint. But I understand what you're saying also. Videos change the world. Hello?
Hi, Commissioner. Peter's still on the call. Oh, there we go. Okay. Sorry.
I dropped, like, I don't know what was going on. My video started freezing and I just like took myself off because I felt like I was about to like be kicked out. So I feel good about it now. Sorry about that. Can you repeat it? It was going in and out for me.
Okay, I was saying that because we have investigators, and I would add some skilled investigators at this point, a lot of this information can be gotten through their investigation. And before we let any complaint be deemed incomplete, we should make sure that we have done everything we can to get the identifying information for the complainant.
Yeah. And I think it can't be complete, right? Because it has to be an iterative process. One of the things here, it fails to include specific location information. I think that's fair because if you're complaining, you should have been in the place, like you should know what the
Where it
place was. Like you can't be complaining about like, I think that's very fair. Description of a summary of the incident appears to be incomplete, missing necessary details and information. So here it's
People should know what they're complaining about. is
yeah, I
basically-
think that I think the fourth point just needs to be more missing necessary details or information. It feels subjective, and that's why
Yeah.
like missing necessary detail. I don't know what exactly those details are. My bigger issue is the first two bullet points, I think, are kind of the same thing. And by adopting that, like we need a proviso there that says like not including, because we could find a sustained finding against that officer. And like if the police department sees the video and they know who that is, but for some reason don't tell us who it is, I think it's very fair for the CRB to say, we saw that conduct, we heard the testimony, and that is a sustained finding against a BPD officer. And so like whoever that officer is, commissioner, you know who they are and you know how to find them. This was the rule violation in that. And we wouldn't be able to tell on the matrix like if this person has done it before, but we'd say if this is their first offense, then it's this. If it's a repeat offender, then it's this, right? Like I think we need to be able to say that, and we can't adopt a regulation that ties our hands in that way.
Yes.
Commissioners,
um,
sorry to interrupt, would it help if
Yeah.
we change the language to say the OPAT staff may consider a complaint incomplete to give a little leeway there?
Yes, may consider, and I think we need a proviso on the first two that says if there is video, photos, audio, and other like kind of real identifying information, like like we need to say video, audio, photos, and like kind of like I think of the post too, right? Like some people are under a pseudonym, right? And so like, but there's ways to determine if that pseudonym, like we did in the other sustained finding, people knew who that officer was, even though it wasn't his direct name, right? I'm thinking of all of these things together. And I think we just need to like, we need to add a proviso that like, if you can like that basically carves out, yeah, we don't have the officer's name, first and last name, badge number, precinct, but video, audio, photos, social media pages, and posts can suffice to identify and identify an officer. Like, and that wouldn't be considered incomplete. Like if you have one of those, I understand if it's just like someone saying it's an office, like someone saying it was a Hispanic male officer, probably isn't going to be too helpful, right? Like, so you're not going to be able to do that. But like, we just need to make clear that like some information and some evidence, like some of that more, kind of like, what is it in judge in terms of like trial, there's like there's circumstantial and what's the other evidence, it's I always say like hard evidence, but
Excellent. Yes. That is
like yeah, so like if you have video, audio, photographs, social media posts, etc., like yeah, like only contains and no other identifiable information, Or I may even want the video, audio, photographs, social media posts, like being sufficient, like with like precinct, but with video, audio, social media posts being sufficient, like saying that is sufficient, right, is going to be important. I think, I guess in your IE badge number precinct, putting it in that, badge, like that stuff, putting it in that list does do the trick. I think it does the trick there.
And I just wanted to add that in some cases where we cannot identify who the police officer is after exhaustive investigation, we should still be able to make a finding of improper behavior by a police officer unnamed,
Yeah,
so that it's
yeah,
on the record. And
yeah.
if at some later point, we should be able to, we identify the person, then we can move forward. But we should not just let it go because we don't have a name or badge number.
Yeah, I take that like, right, if somebody is recording audio, right, and they have audio of someone that is BPD kind of berating them and treating them poorly, but they don't know the officer's name, the officer doesn't give it a name, badge, they're kind of like hamstrung in being able to even say what occurred. And I don't want that to be prohibitive of someone being able to make a finding. Like we don't have voice recognition software, but that can't be a reason to dismiss a complaint. So I do think the affirmative, like that we can make a finding if so OPAT, I think we need to be able to say like a notwithstanding type thing, like OPAT staff, right? Like maybe in that 103 continued if we go down. So I think I'm comfortable here, right? But I think if we go here, we need to specifically state at this point to address Commissioner Harris and my concern, we need to specifically address the issue that we can make findings on unidentified officers to the extent there is like evidence of misconduct, right? Like video, audio, social media, whatever. We know this is a BPD officer, but we don't know who exactly it is. We need to be able to, and I think you can use the same phrasing from up there in the case of these things. We can still make findings against unnamed officers to the extent we have this and we know they're BPD, right? Like
Commissioner,
that.
Yeah.
if I may,
Yeah.
I think that would probably be a separate regulation from this because this is specifically about incomplete complaints. So I'm not saying that this can't be
Oh
a
yeah.
regulation going forward. It just might need to be like go through a whole separate process of like being introduced and open for public comment and all of that.
Okay, can we add that then to like the like I think we should, that needs to be there. And I think we're that in practice, that's how we will operate, but we do need to adopt that regulation. So if that could go into public comment, I understand the dynamic here where this is like about incomplete complaints. And I
So
think
the way that
we
it would,
adopt,
oh, sorry, Commissioner, the way that it would work is that you would draft up the language and you'd have to introduce it at an OPAT Commission meeting. And then we would have to hold a hearing to accept the public comment and then vote on
yeah,
it at the following meeting.
yep. Could I present it in other business in this meeting?
It would have to be properly noticed with like the language available publicly. So it would probably be for the next OPAT Commission meeting, assuming you send me the language.
Yeah, I
and
was gonna
correct-
say present it, but not, it wouldn't be like, it would present it for the next meeting, so there'd be enough time for people to comment on it. That's what I mean. Like
Okay, yeah.
it's not presenting it for us to vote on it today. It's presenting it so that it could be noticed at the next meeting.
Yep,
All
that's
right,
fine.
so we can do that and we'll draft it up, Judge, you and I, in the other business time. That way it could be just ready for the next meeting. And I think that makes sense. Thank you, OPAT.
Can I ask a question?
Yeah.
I'm trying to remember a statute of limitations, and if there is one, on filing a complaint.
No, that folks can make the complaints as long as that, yeah, they can make complaints. and OPAT, correct me if I'm wrong, I think the ordinance allows them to make a complaint. And I do think that there hasn't really been an issue. There hasn't been an influx of complaints from like 10 years ago, right? It's just complaints. Typically, the complaints have been in the last 2 to 3 years. So there's not a concern of overflow. I actually still feel like there's a concern of underflow. So like there hasn't, a sustained finding. The civilian review board can still hear things, no matter how far back. If the evidence is there and it's ripe, and you could still, we still have a way to make a determination that's fair. We can still make a determination no matter how far back it went. So there's no kind of limit going back. Again, OPAT, you can correct me if I'm wrong. That's my understanding on the reading the ordinance.
No, that's correct. So there's no statute of limitations. The only concern is that evidence from longer ago might not still be available.
Yeah.
Yep. And it has to be an active police officer, I would imagine.
Yeah.
Yeah.
In order to recommend discipline, I mean, I think there could be a universe where not an active police officer, we can make a finding, but there's not really anything, sustained finding, but there's nothing you can really do with it because the officer is not an active police officer, right? You can't recommend anything. So, all right, awesome. Thank you. I think the rest of this is fine.
Commissioner, this is one of our intake specialists flagged the language in right here. And I would like to suggest that we make it a more general language about reaching out to the complainant, just because not everyone includes their mailing address. And there's like a whole process for certified letters. So something along the lines of shall reach out to or shall communicate to the complainant.
Yeah, I think if they do leave their address, that, certified mail, like, because that's kind of an identity. If they do leave their address, I do think it might make sense to make sure. And it could just be a proviso. If an address, they would send certified mail, which means like you know when it got delivered and you ensure delivery occurred. I wouldn't say like return receipt requested or a signature or something. It's just like you can track it and you know when it arrived. I think it's like if they provided an address, you send a certified letter. If no address is provided, other reasonable means of, communication, that could be email, phone calls, whatever, like other reasonable means to in good faith find like the communication, like shall notify the complainant stating OPAT has been unsuccessful in reaching the complainant by phone or email in order to continue with the so I think here OPAT staff will notify the complainant stating so how would we, so like we're notifying them if we leave them a voicemail and an email. I guess we do need to, if we don't have an address, if we have an address, I think certified mail makes sense. We haven't been able to get you. So I think we need to note that, like,
I think that the way that the language is with the edit allows us to do the certified mail if there is a mailing address, but also gives us the flexibility to reach out via phone if they only provided a phone number, or via email if they only provided an email address.
Yeah. Yeah, I mean, I guess I wouldn't want to make any additional operational logistical burdens. I think the office has a lot. OPAT staff shall notify the complainant stating OPAT has been unsuccessful in reaching the complainant by phone or email. Yeah, I think that's will, like, OPAT staff shall notify. Yeah, because it's actually shall, like, I mean, shall notify the complainant. I think you almost have to say shall make best efforts to notify, because like what is notification actually mean? You have to do best efforts, because otherwise, like, did you notify them by leaving a voicemail? That's best efforts if that's the only thing you have to notify them. But like, is it officially notification if they're, voicemail box, they don't have the password to it or can't listen? Like, we don't know. We just have to say the only thing that they could do is shall make best efforts, or use, I would say use best efforts to notify the complainant. Like I say, you could say best efforts via phone, email, postal mail if an address provided, or postal mail if an address provided. That way you kind of just say what best, like we used best efforts, we left a voicemail, or we wrote several emails, we wrote an email saying this, or we sent a letter.
Now, just to add, I live in the Grove Hall section of Roxbury. We don't always get mail every day.
Mhm.
Sometimes we go 3 or 4 days before we get mail. So a complainant in my neighborhood, we might send a letter to them and start counting the dates. But they have not received the letter sometime for a week. I just want that to be on the record, that sometimes it's not their fault that they have not responded.
So here it says receipt of, we got to change the letter to such communication, like, so it says, or email, in order to continue the form of the complainant shall contact, Pat, you're dealing with 2 lawyers now. We're about to be drafting here. So in order to continue with the formal investigation, the complainant should contact OPAT during normal business hours. If OPAT does not hear from the complainant within 7 days of receipt of the letter. So here we're changing it so that it's notification, phone, email. I mean, yeah, like receipt of such communication, like, receipt of such notification. So I think within 7 days, maybe, I think I want to change that to like 14.
Commissioners, if I may, I've highlighted
Yeah.
a section of the regulations that states that if it's a lack of contact, that's the issue, the case can be reopened.
Okay, no, I think that works then for the 7 days. I do think expediting is important so folks can know what's to be processed for the next meeting. So like, as long as they have the opportunity, like if they, I just don't want a complaint to be like, oh, well, you didn't get it back, we didn't hear from you within 7 days. And I guess what's the receipt, right? I think that's the thing, right? Like, so if you mail something out, what is the receipt of that? I think we may have to put like, because I think the receipt on an email, right, for most legal documents is when sent. The assumption is if the email was sent to the identified address, then on that day, that was the receipt. In postal mail, if you don't have certified mail, that's why I think we may need to have like certified mail in order to like tie it out if there is an address, because otherwise you don't know when the delivery. So like, I think if someone put it in a mailbox, the certified mail was there, like, again, we can only work within the confines here, and this isn't like criminal law where you get a summons and all of that, and like there's the consequences of it are like, you can be held in contempt of court or something, right? Here it's more about process and efficiency. So, but I do think for the reg, we need to say if there's an address, it's certified mail in order to put that 7 days of receipt, because otherwise receipt, there's a big snowstorm, receipt can be 10 days after it's been sent, right? Like we saw, like kind of post-COVID, like the mail was really slow for months on end, right? I want our regs to account for that. Like if we have an address, it has to be certified mail. I think it's reasonable to know if someone sent an email or there's a voicemail left. I think it's reasonable to expect that, like, upon that being left, if it's the number or email that was provided, that has to be receipt. that's the only reasonable way to think about it. But with physical mail, I think there's so much that can happen in between that we need it to be certified mail in the reg in order for that to work in terms of saying after 7 days, we consider it. What are your thoughts, OPAT?
Commissioner, I just added certified mail to instead of just mail.
Yeah. Yeah. Okay.
Okay.
Yep. Yep. So like on certified mail, yeah, exactly. That's great. So OPAT shall testify if OPAT. All right. Awesome. I think the rest, I'm good. Thank you for the flag too. That's why it's great for everyone to review this and, they know their processes and what, kind of what goes into like these when they're trying to find out who, like find out more information from complainants. So, that's great. Thank the staff for their comment there.
I'll pass along the message.
Yeah. Okay. Okay, 1.04, Judge. This is one that I think both of us probably are gonna have a strong interest in, and this is what happens, for example, when conflicts arising in board participation. I think your panel has had that already. And the CRB has had it with the lack of quorum, a conflict where there's no quorum, and we want to get we want to make sure that the complaint is heard. And I I'm going to suggest here, and I feel pretty strongly, and Judge, curious here what your thoughts are. I want to propose here on the final paragraph that shall the members of IOP and or the CRB fail to achieve quorum for consecutive. No, I just think it's one meeting. I don't think we should be punting. So like if we don't have quorum in one meeting, like CRB meets 2 days before the commission, we have enough time to put that on the commission calendar that day to notice, right? You have 48 hours. If we were slated to hear those cases, but we didn't have quorum, I think it's fair game for the commission to just hear those cases and add them to the commission agenda.
I agree with you because
Yeah.
we don't want people to be delayed because of us.
Yeah. Yeah.
So
So to the extent, yeah. So if we could say just one meeting, OPAT, I think it's just one meeting. And I think we just need to make sure as we calendar things, that the commission meeting is 2 days. Is it 48 hours or 2 days? What's the exact, because I think that would affect times, right? So you may need the commission meeting to be later in the day. If the CRB is later in the day, I just want to make sure we, is it 48 hours or 2 days?
It's 48 hours.
Okay. Yeah. So, just thinking about that, if CRB remains at 11, then the commission can be at 11. Oh, well, it might have to be at 1, right? After the meeting's done. And because it probably will just be the same time, because if you don't have a quorum, you didn't really have a meeting. So you'll notice it right there. And so I think we should be fine there. So we just need to make sure that the meetings kind of run, that a commission meeting isn't earlier than a CRB meeting in which there's no quorum.
Commissioner,
I
I
think
think
that's-
that open meeting law allows for some flexibility with the agenda as long as it's something that was unavoidable.
Okay. All right. Awesome. Yeah, because that would be something. Yeah. So I think an hour difference, I just get super technical, but I think an hour difference would fall into that. It's unavoidable. There was a conflict. There was a lack of quorum. It needs to be heard. I think it's in the public interest as well. So I think some of the ethos around open meeting is like to be in the public interest. And I think it is in the public interest. They've already been noticed on what's going to be heard for CRB. So there's already been noticed. It's just adding it to the OPAT Commission agenda instead. So I agree. I think that makes sense. Appreciate that background. So review and recommendation by the OPAT Commission to respective authority for. Okay. Yep. I think that's 1, 5. I think the rest of these are fine. It's my understanding that on 1.06, adopting a regulation on having a youth advisory council, there may be some pushback against that.
Yeah,
Given that,
Commissioner,
like,
that's correct. The law
Yeah, go ahead.
department said that if we did want to codify the Youth Advisory Council, it would have to be through ordinance and not via the regulations for OPAT. Which is not to say that we wouldn't have this council and follow these how it's laid out here. It's just that it's not appropriate to be included in regulations.
Yeah, so I mean, the way I hear that is we can have
Mm.
something where it's kind of a youth advisory, like, kind of advisory board of sorts that cannot be codified, but it can exist right now and maybe even follow the way that this lays it out, but it's not codified. So like at any given time, it doesn't have to exist if someone doesn't want it to exist, or it can take a different form or have a different number of people than what's there, and all of that understood. Getting it through an ordinance, ideally we can get that done and we could present it to the city council, but it is something that I think is important. I think we are going to keep doing it, and I think to the extent we should put the work into to get it codified itself. And OPAT, is it your understanding that the other kind of advisory councils attached to different agencies and boards, those work through ordinance as well?
I believe the only other advisory council, only other youth advisory council is the mayor's youth council, which yes, I believe was codified through ordinance.
I'm not going to disagree with them, but I think we're splitting hairs in some ways. They have no official capacity, but let's get it, passed through the council so that it's not an issue.
Yeah. So we'll have to take that. I agree with you, Judge, but I think we can still operate in this way, but let's
Yeah.
just try to get it, let's just try to get it done. And I understand partly too, because we were going to do a stipend. And so that's actually public dollars. And I do
Yeah.
think that's probably the tough part to
If it's
codify
volunteer, yeah.
the spending. Yeah.
If it's volunteer, no issue. If it's with the stipend, I agree with you. We need to get it through codification.
Yeah. Okay. All right. So go down. Oh, that's all of them, right? OPAT.
Yeah.
All right. OPAT, were there any public comments via email sent over that we should just consider right now? Since I just want to consider that right now.
There were none.
There were none. Okay. And there aren't any in the comment boxes here right now either, right?
No, and there's no one in the attendees room except for one of my staff members, our community mediator.
Okay. All right. So we can now move on to the meeting dates for 2024.
Commissioners, I think you need to vote to adopt the regulations.
Oh, okay. So
moved.
All right. So moved. I second, and I all in favor?
Aye.
Aye to adopt these regulations. So the ayes have it. We've adopted the regulations as with these revisions and present them. Thank you. All right. So do you have the proposed dates up?
So I'm gonna have a problem. I can't go into my calendar.
Let's
So,
see.
but I've always.
Could you share? Is it possible to share them, OPAT? Let's see. or just the dates there. So the dates themselves are, there you go. Awesome. Thank you, OPAT. So January 23rd, April 23rd. Just check a couple of these. So one of the things, Judge, that we heard as public comment for the CRB meeting is for us in particular, and I'm sympathetic to it, that we need to have diverse timing, having them at the same time, like, right, having it at 11 in the middle of the workday. If someone is complaining and they need to go, they need to take time off work. We just need to allow an opportunity for folks that want to attend. It's fine to have some at 11, but we probably need to also couple it with some at 4, where someone just leaves early, and kind of take the balance into account. When I'm thinking, if we're going to have a meeting at 4 or 3, some of our CRB meetings take place and they could be, 4.5 hours long if we have a backlog. I'm really cognizant of just travel, folks having to go home, when it's nighttime outside, kind of like any employer, how like some employers will, get you an Uber or a cab if you're, going home too late, right? I'm cognizant of folks like having to take the T or ride a bike at night, right? Like in leaving a meeting. And so I kind of think that maybe the April and July meetings are ones that we do later in the day. This is for CRB. Could also be for our OPAT commission as well. But just something I wanted to comment on, because it did come up where folks said, like, there is something to maybe even, and I think CRB members as well, like, and we think a lot about our youth member. We're going to have a youth member, and our youth members are likely either starting out their career, so they may have an hourly wage or what have you. They may be in college, or they may be a senior in high school, which actually means in each case they may have less flexibility of taking time out in the middle of the day. And so if we made it 3 or 4, we'd be able to account for that, and the youth members either out of school or they're not going to have, so I think especially if you have April and July being the 2 days, that also aligns with like nighttime and all of that, where we start later in the day. I think the dates here are fine. Let me just double check. 23rd. If we could have April 23rd, that is going to be, I will not be here in town. So I think that can be resolved, but yeah, I won't be in town on the 23rd. So maybe in that instance, the commission date of the 25th, and then we have a commission on the 30th instead, Tuesday the 30th, to kind of keep that same cadence, if that's okay with you, Judge.
You talking about in April?
April, yeah, to change the commission date to the 30th and the CRB date to April 25th.
That's not a problem for me.
Okay. All right. I think that will work. The 25th and the 30th, if we could do that. Just because, I'm cognizant that I think the CRB meeting can continue and you have a pro temp chair for the folks, but I don't want to take the risk of lack of quorum, because I know for a fact right now I won't be there. So I wouldn't want to schedule anything when any of our members, I know they can't make it. And with that being said, OPAT, I know some of the CRB members have shared certain availability restrictions in terms of time. So I want to kind of talk about time as well. So the April date is the one that I think we have most kind of like issue with at the moment?
Commissioner, sorry to interrupt. I think, so the proposed calendar is mostly to set out the dates, and then the boards themselves kind of decide what time they
The
want to
time?
have the meetings.
Okay. All right, but for January's meeting for CRB, that one's gonna be typical time 11, and maybe in new business, we can cover the times that folks want to meet and people can calendar it.
That's correct. And also,
Okay,
as chair of the Civilian Review Board, if there is a date that you would like to change, and this is part of the regulations that you guys just passed, it says that the chair of the board can make adjustments to the calendar.
okay, all right. Yeah, so the dates there would be the commission and CRB for April moving. So the CRB would be the 25th, and the commission would be the 30th, the Tuesday following that Thursday. And that's the only one. Judge, do you see, if you could scroll down so Judge could see the internal affairs oversight panel?
I don't think there's February 29th. They work for me.
Okay. All right, so I think we can adopt that with that change to the swap, the commission and civilian review board changes for the April meetings. We can adopt these dates with the civilian review board being April 25th, Thursday, and the commission meeting being the following Tuesday in
Yeah,
April.
because it's just us, you and me,
Yeah.
and whoever
Yeah.
the new director is. So
Yeah, sounds good. Okay, we can move to adopt the meeting dates.
so moved.
So, all right, so all in favor? Aye.
Aye.
All right, the ayes have it. That is going to be the calendar with those slight adjustments for the April meetings. So the other business, if you could open a blank page, possibly OPAT, I just wanna, the other business is just kind of draft, and I can put it in a comment box, but just so it's visible there. The way that we want to write that reg that can be, presented and noticed and everything. I'm gonna write it, and then Judge Harris, you could look in the comments and see, but if we could, once it's written, like we could just put it up because that is the comment itself. I'm just need a moment to write it, but I just want it out there sooner, so I'd like it out there today.
Okay. I'm
So what I wrote there is And I think you could say, because some of it, I think when IOP has a civilian complaint that they're overseeing, it's one that the disposition already happened. So in those cases, I don't think you deal with unnamed officers because you're looking at it afterwards. Like, so like the officers named, you're looking at the disposition against them. So I limit it to CRB, but it, just to repeat it out loud, other businesses could be a reg that we'd want to propose when it comes to OPAT being able to investigate and CRB able to make determinations. So OPAT may conduct an investigation with respect to, and the CRB may make findings regarding unnamed officers to the extent other identifiable information is provided, including but not limited to audio, photos, video, voicemail, social media profiles, and witness testimony as to the officer's identity.
Okay, well, now that it's out there, people can comment, edit, and other things. So I think that's a great start.
Yeah, and I think the witness, I think I want to limit as to the officer's identity should only be, so I'm just like revising my because I don't want as to the witness identities to qualify everything, because I don't think, right, you have video or photo, the witness testimony, I'm just going to change this limited to witness. I'm just going to revise to the officers. The witness testimony as to the officer's identity is meant for, you know, someone saw video and they're like, oh, I know who that is, but it's not official. It's like, that is this officer, right? And then you can go and use that. You know, if a witness is there, but the complainant didn't know who the officer was, and maybe the police department didn't verify who the officer was, but maybe there were other witnesses and they're like, I know that officer, it is officer so-and-so, like that needs to be able to be weighed. So, so this is how to make sure we don't have it qualifying everything. I think that, and OPAT and judge tell me if that fixes it. I moved that to the beginning because I think having it at the end makes it sound like it is qualifying everything. And here it's just one piece. Right, moving it there kind of fixed that problem I was seeing in terms of like, you know, if someone read it strictly, they could interpret it differently.
Yes. And
Yeah.
I'm gonna live with it for a while since we have time.
Yeah.
And
So
visit it, you know.
yeah. So the second one, OPAT, is the one that can be noticed, and obviously the OPAT internal body can take a look and see how they want to, you know, propose it or think about it. But that's one we want to like put forward just to clarify that that's what we intend to do. All right.
Okay.
I think we can move to the next order of business here, which is, open it up for any public comment. I don't think that there's anyone on the line currently. And is there any other public comments to be shared? OPAT, not necessarily regarding regs, but anything else shared?
No, there were no comments received via email, and there is still no one in the attendees room.
All right. Okay,
So
well, yeah. Well, I moved to close public comment.
yes.
All right. For those, yeah, so adjourning, I move to adjourn at
Second.
10:38. Seconded. All in favor? Aye.
Aye.
Aye. 10:38. This meeting, this public OPAT Commission meeting is adjourned. Thank you.
Thank you. And thank you, OPAT.
Thank you, OPAT.
Happy holidays to the both of you.
Okay.
Bye.
Take care. Pete, if you get a chance, watch Murder in Boston on
Okay.
HBO.
Wait, I think I do. I have seen that. Okay, will do. I think
Okay.
it's on HBO, right?
Yes.
Yeah. I'm like halfway. I'm halfway through, so
The
I'm definitely doing that.
newspaper